September 30, 2015, Oklahoma State Penitentiary, McAlester. Richard Glossip woke up that morning knowing this was the day he was going to die. He had been on death row for 11 years. He had watched other men eat their last meals and walk down that corridor. He had said goodbye to people through bulletproof glass. He had listened to executions happen in the building around him, and now it was his turn. He ordered his last meal at 10 a.m. He ate it. He called his wife. He told her he loved her. He spoke to reporters from Sky News through a telephone in his cell. His voice was calm, almost eerily so. He said he was not afraid. He said he was innocent. He had been saying that for 18 years and nobody who mattered had listened. The chaplain came to sit with him. That's standard procedure for the final hours before execution, a courtesy, a presence. At 3 p.m., Richard Glossip was still alive. The execution was scheduled for 3 p.m. Then a warden came to his cell. The execution was postponed. The state of Oklahoma had ordered the wrong drug. Instead of potassium chloride, the drug approved in their lethal injection protocol, the prison pharmacy had delivered potassium acetate. Different compound, wrong bottle. Somebody grabbed the wrong box off a shelf. A clerical error. That's what saved Richard Glossip's life on September 30, 2015. Not a court ruling, not new evidence, not a governor's mercy. A pharmacist grabbed the wrong bottle. He would get 2 more reprieves that October. He would get 6 more execution dates over the following years. By the time he walked out of an Oklahoma County jail in May 2026, he had survived 9 scheduled executions. He had eaten 3 last meals. He had said goodbye to his wife so many times that they stopped counting. And every single time he told anyone who would listen, "I didn't do it. I never planned anyone's murder. The man who told you I did is lying." For 29 years, the state of Oklahoma said, "Prove it." It took 8 boxes of withheld documents, including a prosecutor's own handwritten notes proving her star witness lied on the stand, before anyone in power believed him. This is the story of how a motel manager in Oklahoma City ended up on death row for a crime that a 19-year-old meth addict committed, and how the system that put him there protected itself for nearly 3 decades before the highest court in the country finally said, "Enough." My name is Richard Glossip, and I have been waiting for this moment for 18 years. He said that in 2015, 90 minutes before he thought he was going to die. He was still waiting in 2026. Before we talk about the 9 execution dates, we have to go back to the beginning, to a budget motel on Meridian Avenue in Oklahoma City in January of 1997. Barry Van Treese was 54 years old. He was a businessman, a husband, a father of 6. He had spent decades building a chain of budget motels across Oklahoma and Kansas, properties that weren't luxury destinations but that served their purpose: cheap, clean enough, functional. The Best Budget Inn on Meridian Avenue was one of them, not his most profitable location. In fact, by late 1996 it had become a problem. The motel was losing money, revenue was down, the books didn't look right. Van Treese suspected his manager was the issue. That manager was Richard Glossip. Richard Glossip had been working for Van Treese for years. He managed the day-to-day operations of the Best Budget Inn, handled check-ins, dealt with vendors, managed the staff, kept the place running. He was not getting rich doing it. He lived at the motel. He didn't own a car. By most accounts, he was a competent manager who kept the place functional if not thriving. But the books were off, and Van Treese was coming to find out why. On the night of January 7, 1997, Van Treese drove from his home in Yukon to Oklahoma City. He checked into the Best Budget Inn as a guest, room 102. He planned to do a full audit the following morning. He was not happy. He had told people in the days before that if the numbers didn't add up, Glossip was finished. Justin Sneed was 19 years old. He was a high school dropout with no steady income and a serious methamphetamine habit. He had been staying at the Best Budget Inn rent-free in exchange for doing maintenance work around the property. That was an arrangement Glossip had allowed. Sneed lived in his room. He worked when asked. He used drugs. He was the kind of person that a low-end motel accumulates by default, someone with nowhere else to go and no one looking too closely. On the night of January 7, Justin Sneed entered room 102 of the Best Budget Inn. Barry Van Treese was sleeping. Sneed had brought a baseball bat. What happened next is not in dispute. Sneed beat Barry Van Treese to death. He struck him repeatedly in the head, fractured his skull in multiple places. Van Treese suffered catastrophic injuries. He did not survive. Sneed then left room 102, went back to his own room, and went to sleep. The next morning, he showed up for work as usual. It was a housekeeper who found Barry Van Treese's body stuffed in a closet. She called the police. Within hours, Justin Sneed had been identified as the prime suspect. He was brought in for questioning. He confessed to the killing almost immediately. And then, facing the death penalty, facing execution, he told the detectives something else. He said Richard Glossip had put him up to it. He said Glossip had told him that Van Treese was coming to fire him and that he needed Van Treese to disappear. He said Glossip had promised him money, $10,000, to commit the murder. That was Justin Sneed's story on January 8, 1997. It would be the only story he ever told, and Richard Glossip's life would be defined entirely by it. Here is what the prosecution had after Justin Sneed gave his statement. They had a confessed killer, a 19-year-old meth addict who had just admitted to beating a man to death with a baseball bat. They had his word that Richard Glossip, the motel manager, had ordered the killing. They had no physical evidence connecting Glossip to the crime. No DNA, no fingerprints, no witness who saw Glossip plan anything, no money changing hands, no phone calls, no notes. Nothing except the testimony of the man who did the killing. In the American legal system, this creates a problem. A co-defendant's testimony against another defendant is inherently suspect. Courts have long recognized this. A person who is facing execution has an enormous incentive to say whatever prosecutors need to hear. The question is always, do you have anything else? Oklahoma County prosecutors made a decision. They offered Justin Sneed a deal. Testify against Richard Glossip at trial. Say on the stand what you told us in that interrogation room, and in exchange we will take the death penalty off the table. You will plead guilty to murder. You will receive life in prison without the possibility of parole, but you will not be executed. Justin Sneed took the deal. He was 19 years old and he had just beaten a man to death with a baseball bat. Life without parole versus execution is not a difficult calculation. He took it. From that moment on, the entire architecture of the prosecution against Richard Glossip rested on one foundation: Justin Sneed's credibility. If Sneed was believable, if the jury looked at him and thought this man is telling the truth, then Glossip was guilty. If Sneed was not believable, if the jury thought this is a killer who is lying to save himself, then there was no case. Everything depended on that one man's credibility. That is not unusual in itself. Cooperating witnesses make cases all the time. What matters is whether there is corroborating evidence and whether the prosecution is honest about the limits of their case. In the first trial in 1998, the jury believed Sneed. They convicted Glossip and sentenced him to death. 3 years later, the Oklahoma Court of Criminal Appeals threw out the conviction, not because they thought Glossip was innocent, because his lawyer had been constitutionally inadequate. The court described the evidence as extremely weak. A new trial was ordered. Most people in that situation, with the court itself calling the case extremely weak, would not face a second trial. Oklahoma retried Richard Glossip anyway. In August 2004, Justin Sneed took the stand again. He told the same story: no new evidence, no new witnesses, the same man, the same deal, the same testimony 7 years later. The second jury convicted Glossip, sentenced him to death again. He had been convicted of murder twice on the testimony of one witness, a witness who had personally committed the crime, a witness who was now serving life in prison instead of being executed because of the testimony he gave. Richard Glossip went to death row for the second time. He was 40 years old. He would be there for more than 2 more decades. Death row is a specific kind of waiting. You know your sentence, you know what it means, you just don't know when. Richard Glossip spent his years there filing appeals, fighting his conviction through the courts, maintaining his innocence to anyone who would listen. Most of his appeals failed. The federal courts deferred to the state courts. The state courts upheld the conviction. The system that had convicted him was not eager to reverse itself. In 2015, Oklahoma set his execution date for September 30. Lead up to that date became unexpectedly an international story. Richard Branson, the British billionaire founder of Virgin, became convinced that Glossip was innocent after reading the case files. He purchased a full-page advertisement in an Oklahoma City newspaper. The headline read, "Evidence against Glossip is flawed." Sister Helen Prejean, the nun who administered to death row inmates for decades, and whose story inspired the film Dead Man Walking, publicly advocated for him. Dr. Phil McGraw did segments about the case on his television program. Kim Kardashian tweeted about it. None of it moved the courts. September 30, 2015, Glossip ate his last meal, said goodbye to his wife, spoke to British journalists on the telephone from his cell. The chaplain sat with him. Then, less than 2 hours before the scheduled injection, the warden came to his cell. The execution was postponed. Oklahoma had received the wrong drug. The state's lethal injection protocol called for potassium chloride. What had been delivered was potassium acetate. Different compound, same name, different formula. The prison's pharmacy had made an error. Oklahoma Governor Mary Fallin granted a stay not because she had doubts about Glossip's guilt, but because the state was not legally authorized to execute someone with the wrong chemical. He received 2 more execution dates in October 2015. Both were stayed. Then came years more of legal maneuvering, more appeals, more denials, more dates set and stayed. In 2022, Oklahoma scheduled another execution for May 18, 2023. That one was halted by the United States Supreme Court, not on the merits of innocence, but while they considered whether to take his case. By the time the court finally ruled in February 2025, Glossip had accumulated 9 separate execution dates. He had eaten 3 last meals, because twice he had been stayed after the meal was already served. He had said goodbye to his wife so many times that the phrase had lost its ordinary meaning and acquired a different one, a darker one, a kind of rehearsed devastation that he had to perform on demand. He had survived 9 scheduled deaths. Not because anyone in power believed him, because of drugs that were wrong, because of courts that were late, because of procedural timing. His innocence, or lack of it, had almost nothing to do with why he was still alive. In 2022, something unusual happened in Oklahoma. The state legislature, a Republican-dominated body in a conservative state with a strong historical support for the death penalty, passed a bill. The bill authorized an independent investigation of the Richard Glossip case. This almost never happens. State legislatures do not typically intervene in individual death row cases. They pass general laws, set procedures, appropriate budgets. They don't hire investigators to look at one specific conviction. But several Oklahoma lawmakers had become genuinely troubled by what they had seen. Republican Representative Kevin McDougal had looked at the case files and came away disturbed. He said publicly that this case is no longer about justice. It's about power, pride, and politics. The legislature hired an independent investigator, a former federal judge. His job was simple: look at everything. What he found was not in any courtroom record. It was in boxes. 7 boxes of documents that prosecutors had never turned over to the defense. Under Brady v. Maryland, a 1963 Supreme Court decision, prosecutors are constitutionally required to hand over any evidence that might be favorable to the defendant. This is called a Brady disclosure. It doesn't matter if the evidence is inconvenient. It doesn't matter if the prosecution thinks it's minor. If it could help the defense, it goes to the defense. These 7 boxes had not gone to the defense. They had sat undisclosed for more than 20 years, through 2 trials, through dozens of appeals, through 9 execution dates. In those boxes were documents about Justin Sneed, about his mental state at the time of the crime, about things he had said before the trial that complicated his story, about his drug use, about inconsistencies in his account. The independent investigator documented all of it. The findings were turned over to the Oklahoma Attorney General's office. The current Attorney General was Gentner Drummond, a Republican, a man who had been elected on a law and order platform, not exactly the natural champion of a death row inmate. Drummond read the findings. And then he made a decision that had almost no precedent in American legal history. 7 boxes of undisclosed evidence would have been enough to demand a serious review of any conviction. But it was the 8th box that changed everything. The 8th box contained different materials from the first 7, It didn't contain documents the state had merely failed to turn over by oversight. It contained something more specific. It contained the trial prosecutor's own handwritten notes. The prosecutor who had tried Richard Glossip in both 1998 and 2004 was Connie Smotherman. She had made the case against Glossip in both trials. She had built the argument for his guilt. She had put Justin Sneed on the stand. At Glossip's second trial in 2004, Sneed testified about his mental health history. He told the jury this is a direct characterization of his testimony that he had never seen a psychiatrist, that the only psychiatric medication he had ever taken was the result of an accidental prescription. A doctor had prescribed it for a cold mistakenly. It wasn't for any mental illness. He wasn't mentally ill. The jury had no reason to doubt him. This was his personal medical history. Who would lie about that? Connie Smotherman's handwritten notes recovered in the 8th box told a different story. After his arrest in 1997, Justin Sneed had been examined by a jail psychiatrist. He had been diagnosed with bipolar disorder. He had been prescribed lithium not accidentally, not for a cold, but to treat a diagnosed mental illness. His prescription had been written and maintained by medical professionals at the jail. The trial prosecutor's own notes reflected her awareness of all of this. They showed she knew about Sneed's diagnosis. She knew about the lithium prescription. She knew, in other words, that when Sneed told the jury he had never seen a psychiatrist and had only taken psychiatric medication by mistake, he was lying. She said nothing. She let the testimony stand. She built her closing argument on Sneed's credibility. She asked the jury to believe him. She sent Richard Glossip to death row a second time, and the jury did believe Sneed in part because his own lawyer, who should have cross-examined him on his mental health history, never knew that history existed because the prosecution hadn't disclosed it. Why does any of this matter? It matters because of Napu v. Illinois. In 1959, the United States Supreme Court established a clear constitutional rule: a prosecutor cannot knowingly allow a witness to give false testimony, not correct it next year, not correct it on appeal, immediately, in the courtroom, on the record. If a prosecutor knows a witness is lying, she has a constitutional obligation to correct that lie before the jury. Connie Smotherman did not correct it. The evidence of her knowledge was in her own handwriting, in the 8th box, which had not been disclosed for more than 20 years. What happened next in the Richard Glossip case has almost no parallel in modern American legal history. Gentner Drummond, Republican Attorney General of Oklahoma, elected on a platform of law and order, the state's chief law enforcement officer, read the findings of the independent investigation. He reviewed the 7 boxes. He reviewed the 8th box. He reviewed Smotherman's notes. And in March 2023, he filed a motion to stay Richard Glossip's upcoming execution. That alone was extraordinary. The same office that had prosecuted Glossip twice, that had defended his conviction through dozens of appeals, was now asking for the execution to stop. But Drummond went further. He filed a motion to vacate Richard Glossip's conviction entirely. The state of Oklahoma, through its attorney general, argued that the conviction should be thrown out, not retried, thrown out. Drummond said there is enough doubt of his guilt that the death penalty and his conviction for murder is inappropriate. He was careful. He did not say Glossip was innocent. He said, "We are not certain enough to kill this man." That statement from the Republican AG of Oklahoma should have been the end of this case. It wasn't. The Oklahoma Court of Criminal Appeals, the state court with jurisdiction over death penalty cases, rejected Drummond's motion. The same court that had already heard and denied dozens of Glossip's appeals. The same institution that was deeply invested in the finality of this particular conviction. Even with the state's own attorney general asking them to vacate, they said no. So Drummond did something remarkable. He took the case to the United States Supreme Court himself. He filed a brief arguing that Glossip's conviction had been obtained through constitutional violations. The state's own attorney general was arguing before the nation's highest court against the state's own conviction. Oklahoma's position in the Supreme Court was, in effect, our prosecutors broke the law, our courts refused to acknowledge it, we are asking you to fix it. The Supreme Court agreed to hear the case. On February 25, 2025, the court issued its ruling. The vote was 5-4. Justice Neil Gorsuch recused himself, having been involved in the case during his time on the 10th Circuit. Justice Sonia Sotomayor wrote the majority opinion. Justices Alito and Thomas dissented. The majority found that Oklahoma had violated the NAPU standard. The prosecution had known its star witness was lying about his psychiatric history. It had not corrected that lie. The lie was material. It went directly to Snead's credibility, and Snead's credibility was the entire case. A jury that knew the truth about Snead's bipolar disorder, about his lithium prescription, about his documented willingness to perjure himself on the stand, might well have reached a different verdict. Richard Glossip's conviction was vacated. A new trial was ordered. Take a step back from the legal proceedings for a moment and look at what actually happened here. Richard Glossip was convicted in 1998. The only evidence against him was the testimony of the man who committed the murder, who received life in prison instead of death in exchange for that testimony. The conviction was overturned in 2001 not because of innocence but because of ineffective counsel. The court called the evidence extremely weak. Oklahoma retried him anyway. In the second trial, the prosecutor, Connie Smotherman, put the same witness on the stand. That witness told the jury he was mentally healthy, that the only psychiatric medication he had ever taken was an accident. That was a lie. The prosecutor's own notes prove she knew it was a lie. The jury convicted Glossip again. Over the next 20 years, his lawyers filed appeal after appeal. The courts denied them. The withheld boxes, 7 of them plus the 8th with the smoking gun, were not disclosed during any of those appeals. The legal system operated as it often does in cases like this, with a strong institutional preference for finality. The conviction is on the books, the appeals process exists, the appeals failed, the case is closed. Except the evidence hadn't been disclosed. The conviction was built on a lie, and the prosecutor who knew the lie kept it to herself for 27 years. This is not an accident of the system. This is the system operating exactly as it was designed. Prosecutors have almost unlimited discretion in what they disclose and when. The Brady obligation exists in theory, but enforcement is left to the courts, which are reluctant to overturn convictions. The institution is built to maintain its own decisions. Reversals are embarrassments. They suggest the system failed, and institutions rarely enjoy admitting failure. What broke the cycle in the Glossip case was not a court, it was a legislature. A group of Republican lawmakers who read the files and said, "Something is wrong here." They hired an investigator who was not employed by the prosecution or the defense. He looked at the boxes, he found what was in them. And even then, the Oklahoma Court of Criminal Appeals, facing the state's own attorney general arguing the conviction was unconstitutional, said no. It took the United States Supreme Court to impose accountability. The question that doesn't have an easy answer is, what happens to all the cases where there is no legislature funding an independent investigation, where there is no attorney general willing to reverse course, where the Supreme Court doesn't agree to hear the appeal? The Glossip case is exceptional not because prosecutorial misconduct is rare, but because the chain of events that exposed it was almost impossibly unlikely. Every link in that chain had to hold, most don't. On May 14, 2026, Richard Glossip walked out of an Oklahoma county jail. He was 63 years old. He had entered the system at 34. He had 3 last meals on death row, 9 execution dates. He had been spared the final time in 2015 because someone at a pharmacy grabbed the wrong bottle. Outside the jail, his wife was waiting. He had never owned a smartphone. He had spent 3 decades in a cell while the world changed entirely around him. He stepped into a version of Oklahoma City that bore almost no resemblance to the one he'd left. He wore a borrowed suit. But here is what matters and what the coverage of his release mostly obscured. Richard Glossip is not exonerated. He is free on a $500,000 bond. He wears an ankle monitor. He cannot leave the state of Oklahoma. He is required to observe a curfew. He is awaiting retrial. Oklahoma has announced it will retry him in September 2026. The state has said it will not seek the death penalty this time. The current district attorney has indicated she would not pursue capital punishment in this case, but they are not dropping the charges. They still believe, or at least officially maintain, that Richard Glossip solicited the murder of Barry Van Treese in January 1997. And Justin Snead is still alive. He is still in prison serving his life sentence. He has, as far as public record shows, never recanted his testimony. He has never said, "I lied." He told that story in 1997, told it again in 2004, and has maintained it for nearly 30 years. Whether he will be called to testify a third time, and if so, what he will say when faced with a defense that now has access to his psychiatric records, remains to be seen. The retrial will determine, at least legally, whether Richard Glossip is guilty or innocent. But let's be precise about what the Supreme Court's ruling actually established. The court did not find Glossip innocent. It found that his conviction was obtained through a constitutional violation, that the prosecution allowed false testimony to stand when it had an obligation to correct it. That is grounds for a new trial, not grounds for exoneration. In the new trial, the same basic facts will be presented. The same murder, the same motel, the same deal between Sneed and the prosecution. The difference is that Sneed's credibility, always the central pillar of the prosecution's case, has been severely compromised. The jury will know about the bipolar diagnosis. They will know about the lithium prescription. They will know that Sneed lied about his mental health history on the stand, and that the prosecutor who put him there had documentation of that lie in her own handwriting. That is a very different trial from the one Richard Glossip had in 2004. Whether it is enough, whether a jury in 2026 with all of that information will acquit, is something no one can predict. What we do know is this. A man spent 29 years on death row. He survived 9 execution dates. He survived because of wrong drugs and court timing and an independent investigation funded by a state legislature. The prosecutor who convicted him had notes proving her star witness lied, and she said nothing for more than 2 decades. The system that did all of that is the same system that will try him again in September. For Richard Glossip, the question of justice is still open. For the rest of us, another question is worth sitting with. If it took all of this, a billionaire's newspaper ad, a nun's advocacy, a Republican attorney general's reversal, 7 boxes of undisclosed documents, an 8th box with a prosecutor's handwritten proof of her own misconduct, and a 5-4 Supreme Court ruling, just to get to a new trial, how many cases never get that far? How many names we've never heard are still waiting?